Hello and welcome to the Al-Attiyah Foundation podcast. My name is Stephen Cole, and today I'm delighted to be joined by Professor Eduardo Pereira. Professor Pereira is a world-renowned scholar specializing in natural resources and energy law. He's a founding partner at the International Energy Law Training and Research Company, as well as at the International Energy Law Advisory Group. He's been active in this field for more than 15 years and across 50 jurisdictions, covering America, Europe, Africa, and Asia. He completed his PhD in oil and gas joint ventures at the University of Aberdeen and published several books and articles. Eduardo, welcome to the Al-Attiyah Foundation podcast.
Thank you for the invitation, Stephen. It's a pleasure to be here.
Well, you're very welcome. Probably, Eduardo, one of the most important agreements in the fossil fuel industry is the Joint Operating Agreement, a JOA. So, very simply, what is a Joint Operating Agreement and why is it commonly used in the oil and gas industry?
It's a very good question to starting point, Stephen, that the oil and gas industry faces a lot of risks. There are geological risks, there are economical risks, there are political risks, there are security risks, plenty of risks involved in this industry. So in one way that oil and gas industry, and especially oil and gas companies, manage to reduce and mitigate this risk is by teaming up. So this is the essence of the JOA. The JOA is an instrument where the oil and gas companies, they're going to share the risks and collaborate the efforts towards the exploration and development of oil and gas resources.
So what sort of agreements are likely to exist before entering a JOA?
Yes, so the JOA, we'll discuss a bit later, is very much aligned and work together with the host granting instruments because apart from US and some parts of Canada and very specific parts of Trinidad and Tobago, the rest of the world, basically the oil and gas resources belong to the government, to the nation, to the host government. So these countries, they have to authorize investors to do activities in their own territories. So therefore, that this agreement, the JOA, work hand in hand with the granting instruments, maybe the concession, maybe the production share agreement, maybe the service contracts, whatever the agreement is might be. However, before the oil and gas companies are able to sign a granting instruments or a JOA, most likely there might be other agreements in place. Like, for example, confidentiality agreement, they might want to share information to discuss potential business, or maybe they go ahead to go to joint study bid agreement because they team up initially to decide on an area they might want to negotiate with a given government in a PSC, concession, or service agreement. And those agreements especially might be the foundation behind the JOA, because if the bid is successful, they manage to get award of a PSC concession agreement or service contract, then they would be turning into a JOA, because the JOA would probably start when the granting instrument is in place that can conduct activities. So that's why they work hand in hand with the granting instruments. But maybe there are some agreements that might exist before, and maybe we'll discuss a bit later as well, in between, because you might have an assignment like a farm out agreement, sales and purchase agreement, that somebody might sell some of the interest along the way, and that would maybe turn into a JOA if just one party is selling, or if there are more parties involved, then you already have a JOA in place as well.
So how do JOAs differ from other types of agreements? For example, production sharing contracts, PSCs, or service agreements?
Right. It's an interesting point as well. So the JOA itself, as I was just talking before, Stephen, like they generally speaking, they exist in parallel with the ones you mentioned. Because in a PSC, production share agreement, service contract, or a concession, who are the stakeholders involved? Typically is the government at one side and the investor at the other side. In the JOA, typically is the investors agreement, because they would be signed between oil and gas companies to mitigate the risks and the joint several liability that exist in the granting instrument signed with the government. So usually they are different agreements and work in parallel with each other.
So what would you say are the standard legal frameworks or regulations that govern JOAs in different jurisdictions. I mean, how do they affect the negotiation of a JOA? And does it matter if you're in a civil law or common law jurisdiction?
Right. So the GOA tends to be a fairly long agreement. You might have like dozens or even more than 100 pages, depends on the standard you might be using. So the main, and especially with the attachment as well. So you're not going to start this by the scratch. So usually you have standard forms, which are issued by different organizations, different parts of the world. For example, a very famous one, internationally speaking, is called International Association of Energy Negotiators, formerly called AIPN because it changed from the petroleum to energy negotiators. So these are the most agreement you would probably be using if you are not in a jurisdiction that has your own model form. For example, USA, they have their own model form. Canada, they have their own model form. Australia, they have their own model form, and Norway. So unless if you're in a region very developed, has a very strong associations that have the model form, most likely you might use the AIN, which is a very international one, used especially across Africa, South America, some parts of Asia as well. So that's a good starting point, Stephen, because you're not starting from scratch. You are using a model form who has been reviewed and used by several companies throughout maybe even decades, you know. So that's a good starting point. But then doesn't mean that you just copy paste and sign, you know, because you need to understand, because you need to understand as well who are the parties involved, because maybe sometimes you might be a national company, maybe you might be a junior independent company, maybe you might be a major company. So of course you might still tweak and tailor to your own needs and to the case you might be involved. But addressing your other points, Stephen, is that certainly, you know, like especially when you are in the US, you are in the UK, you are in Canada, you are in Australia, generally speaking, you know, because of course there are some exceptions there in Louisiana or Quebec, but generally those countries, they are common law jurisdictions, which the foundation is slightly different than a civil law jurisdiction. Because generally speaking, of course, you need to see the details in the country in case by case. Generally speaking, the common law jurisdictions, they tend to give a little bit more freedom to the parties to agree in their whatever commercial agreements. And the civil law, you might have a little bit more statute limitations and involvement, maybe eventually by the court, as the case might be. So that's why whenever you were addressing a negotiation, you might need to understand some issues. For example, typically in a civil law jurisdiction, you might have in the civil code the principle of good faith. You might have already defined in the civil code force majeure. So you might have some protections that existed even if you do not address that in your contract. But if you are in a common law jurisdiction, you might see a little bit more careful drafting some of these provisions because the law will not give you that by default. And sometimes, as you will see, maybe in part of our discussion here, in some issues involving enforceability of some of these provisions in the GOA, you need to understand as well that if you're in a civil law jurisdiction, does your court or your legal system recognize those principles, or they might have some limitations? So that's why it's very important when you are drafting, negotiating a GOA, you don't only have counsels, business people, lawyers who are familiar with the instruments, the GOA, but also familiar with the applicable law you sign your agreement, or even as well where it is going to be used, because maybe you can even eventually sign a GOA in a different governing law, but then you might be using it in a country which is not the same as you are signing the agreement, which eventually you might have to enforce that provision, that contract in that country. So that's why you need to have local lawyers involved, not only foreign lawyers.
Let's talk a little more, Eduardo, about these best practice guidelines you've been talking about that you adopt in drafting a JOA. They must, as you suggest, vary by region? And what are the key legal considerations to bear in mind to avoid possible mistakes or pitfalls of parties when negotiating or entering into a JOA?
Yeah, it is interesting point as well, Stephen, because like overall, several of these provisions, you know, we will have similar concepts across different provinces, different regions throughout the world. Like for example, you certainly will have definitions, duration of the contract, scope, and what are the parties' participating interest. That's a fundamental provision, because it's like your shares in the project, your shares in the company. Your participating interest is fundamental vis-a-vis your rights and obligations. This is something which could be a significant difference from different parts of the world, operatorship. Because typically in a JOA, you have two types of entities involved. You have an operating party and non-operating. Operator is kind of the leader of the consortium, who is taking the lead in all of these initiatives. And you have the non-operating parties, which is also part of this project as well. So the key issue which you need to understand, that different parts of the world, you put the operator in a much more stronger position. That's a very common approach in North America, especially in the US. So it's more like the operator has really strong power to conduct this as you are maybe like in a plane or in a boat. The captain is really with strong powers. And when you are maybe in internationally speaking, you might have the passengers with a little bit more control of the process to decide a little bit, like you were in a guide tour, that maybe they listen to you a bit more, where you might turn, where you might not turn, So certainly I think that knowing which agreement you might be using, the standard you might be using, you might know from the starting point that you might have maybe more or less rights. Of course, you can tweak and you can adjust to provide. So certainly I think that's a very important provision you might be aware. Another one, even is very complex, I even have a book about that as well. It's called exclusive operations, because even in a relationship, we know that sometimes people might have different views. So it's very difficult that in a long-term relationship, because these agreements, we're talking here, 10, 20, 30 plus years, life might change, things might change. So eventually, this agreement is flexible enough to accommodate that throughout the life of this relationship, people might disagree to do things. And that's a complex, because they are drafted in a way that's something called sole risk and non-consent. The sole risk means that whenever you have a decision and you don't reach the quorum of the minimum of this unity, you allow the parties who lose their voting decision to proceed, the dissenting parties to proceed with that activity. The non-consent is the opposite. The majority prevail, but you still want to be out of that decision. So these are special mechanisms to provide some flexibility to do more work for those who wish to do, or sometimes the minority parties to be out in a thing they do not agree to proceed. But of course, this creates complexities, because when we start this, Stephen, remember, it's about sharing risks. It's about teaming up. And this provision do exactly the opposite. They allow you to break in certain ways part of this joint initiative. So this is one you need to be very careful how to draft this, because you're changing the concept behind. Even though you're trying to keep the unit, but you still need to be careful how to do this and how the applicable law. There are other provisions probably we'll discuss here as well, like the default, because like the core of this agreement is that people should pay what they're supposed to pay when is the time to pay. So it could be very complex if some parties or more than one party is not paying their due payments. That create complexities in the agreement for the cash flows.
How would then those costs and production be typically allocated between operators and non-operators in a JOA?
Right. So typically, as I mentioned before, the participating interest is a core provision here, because that means that whatever participation you have in this project, in this JOA, like 50%, 30%, 80%, 10%, whatever this participation interest you have to pay the cost correlated to that shares. That's the starting point. So imagine we are in the JOA, Steve, both of us. You have 50, I have 50. So the principle is that every cost related to the project, you'll be liable to pay 50%, I'll be liable to pay 50%. But this is not only attached to the obligations, to the rights as well. So whatever production we might be able to develop in this joint venture, in this JOA, 50% I'm entitled to that, and 50% you are entitled to that. So the core rationale in this agreement, even though it's a very short provision, can be even less than a page or even half a page or even a paragraph, the participating interest, it is fundamental for the relationship going forward. So that's why you need to know, of course, that's why the governments also, Steve, they might be considered as well that sometimes they want to limit the minimal participating interest, because this is like a football field that you can bring as many friends as possible to share costs, because they want to have a limited amount of people involved with financial resources to put that. So some countries might even limit the minimum participation each party can have, and especially the operator. Not necessarily, but quite often the operator has some significant shares in this project, because you want to make sure that he's dedicated enough time and attention for this project, so they will be able to be in this position as well.
People on a football field know what they're supposed to do individually. How does a JOA typically allocate the rights and responsibilities between the parties?
Right. So in this case here, the JOA, generally speaking, puts much more strength, details on the role of the operator. As the same way as you are, for example, imagine you are embarking in a tour, you join a bus, you join actually taking a flight or going to cruise ship. Of course, the laws and the regulations put much more details on the captain role, what a captain must do. Of course, even you as a passenger, that you're not even conducting this, you still have rules on how to behave and how to do. In the case of the GOA, what the details they would give is this. Steve, number one, the operator is the one conducting this activity. So he will be acting on behalf of the group to contract with third parties, because what people sometimes forget, is that the oil and gas companies are not usually doing every single piece of the work in this industry. Quite often they outsource, because they will bring technical resources, companies and people to work along different parts of the segment. But who is doing the oversight and management? That is the operator. So there is a lot of rules in terms of how the operator award contracts to third parties, when and how the operator can contract an affiliated group, because of course there might be concerns here that the operator is doing the things for the best interest for the consortium, not for his own group. So there will be procedures in terms of how can award contracts to affiliate companies. There'll be a lot of concerns as well here, as you would imagine, even like issues about health and safety environment, to make sure that the operations are being conducted in a diligent manner with the best industry practice, and the operator is observing this. So there is a lot of things about meeting these obligations, discussions with the government authorities, which usually the operator is in charge of that. And then your question would be, well, how about the others there? How about the passengers? How about the fans in the stadium? What they're supposed to do? The non-operators, generally, the key obligation they have, Stephen, is to pay the dues, pay their cash calls as required, kind of like an investor, in the day that if there is a shareholder meeting, you ask to pay your cash costs. It'll be similar, but also similar to a shareholder agreement meetings, that the non-operators also have rights, so they want to make sure that the business, because if things go wrong, Stephen, which of course nobody wants that and expect that, but towards the government, towards third parties, they are joint and several liable, which means everybody's on the hook. Doesn't matter who did that, everybody. So that's why they are very
so the risk is shared.
They are concerned about that. Of course, the GOA as a principle talk about proportion liability. Remember we discussed, you and I, Steve, 50-50%. So my assumption is that if things don't go well, Steven is going to pay 50, Eduardo is going to pay 50, but towards...
So Eduardo, how are disputes between parties in a JOA be effectively managed or resolved in the event of a big dispute?
Yeah, I mean, like generally speaking, the GOA would provide that the operator is in charge to solve a dispute. Of course, there are two types of disputes here. It could be, several types of dispute. Could be a dispute vis-a-vis some issues with the government, some issues vis-a-vis third parties not related to this, maybe some NGOs, maybe some fishermen, maybe some local communities, or could be some issues related to a service providers that the joint venture, the GOA, outsource the work. So, but in a nutshell, the operator is in charge to handle these disputes, and the non-operator should be informed about that and might have the right to get involved in how to handle that, because certainly this would affect everybody. A bit different if the disputes are between themselves. So that's why, depending on the nature of this dispute, Stephen, we might be talking about maybe a court, or maybe we're talking about arbitration. Generally speaking, an issue between the JOA parties tends to be leading towards arbitration, and generally speaking, a course towards third parties not related to this might be leading towards a court litigation to solve these disputes.
Lastly, Eduardo, is it possible to change the terms of the JOA?
Well, as typically the maximum of contract law, like pacta sunt servanda, which means the contract should be observed, applies to most jurisdictions throughout the world, but of course that there are some issues that might change. First, maybe could be voluntarily. Somebody want to leave, somebody want to sell, that would be actually agreed by the parties. There are some conditions you might want to sell. Maybe you want to give preferential rights, right to first refusal. Maybe you want to leave the agreement and withdraw. Maybe you can do it at some point in time, or just voluntarily throughout the process. You might want to agree different terms. So voluntarily, you could change those terms and conditions as well.
Well, that's excellent. A very, very comprehensive answer. Professor Eduardo Pereira, that question concludes our interview and our podcast. Thank you for giving us your thoughts and opinions on how JOAs work. And thank you to the listeners for tuning in. A new Al-Attiyah Foundation podcast will be released in the coming weeks. In the meantime, be sure to check out our website at abhafoundation.org for our latest publications. But for now, from me, Stephen Cole, and Eduardo, it's goodbye.